dear, that's really poor. That's really poor. Okay. Morton Paint is the key case on precedent in Guernsey. So you really can't get by on talking about precedent without talking about Morton Paint. Just like in Jersey, you couldn't do an answer without talking about Qatar, the state of Qatar and Al-Fani. And ideally, you shouldn't really get by without talking about both of them when you're in either jurisdiction. So, Privy Council on appeal from Guernsey binds Court of Appeal and the Royal Court, and Court of Appeal binds the Royal Court. That is the orthodox point of view in Guernsey, and that is how you have to answer your questions, therefore. And you can discuss difficulties, and you can discuss the fact that Jersey has taken a different approach, but you always have to come back to that, because ultimately a decided case is where the law is the real positive law, and other things a discussion that you need to know about, because it may very well be that you could find yourself in a case where there is a binding Privy Council decision which has actually been repudiated by the Privy Council on appeal from somewhere else, and you might want to very well go in and say in the Royal Court, yes, under Morton and Paint you're technically bound by it, but were they really right in Morton and Paint? Was that really part of the decision? Was that perhaps obiter? And what's more, it's an entirely unrealistic way of viewing precedent, isn't it? And you can build an argument, but for the present purposes, that is the starting point. House of Lords, Supreme Court decisions not binding but given considerable weight. We've dealt with that already. Particularly, if it's following a English statutory model. The Court of Appeal here doesn't bind itself, Smith and Harvey, and there's a good reason why it doesn't bind itself. It is, in many ways, the safety valve of the system. There are comparatively few Court of Appeal cases, so the dynamic that Sir John Laws refers to doesn't really apply with the Guernsey Court of Appeal. You've got no control in the system as to whether the Privy Council is going to accept an appeal or not. It will tend to do so if it thinks that actually from Guernsey, it has to do it if it's a money claim above about £50. But otherwise, if it's got any choice in the matter, it accepts the claim, it accepts the appeal if it thinks it's of importance. It might not necessarily be too sensitive to the importance in Guernsey, because it's a time-pressed judges. Yes, 500. 500. It's in the A versus R. They consider it, and again, it's an example of what you get when you have a statute. Is they have to say, well, the statute says what it says. It's in the modern day, it's a little bit ridiculous that to have a right of appeal to the Privy Council if £500 is involved in it. In fact, even in 1961, that really, because that was about 3 months' wages, but it's still not that great a sum in the grand scheme of things. But that's what it says, so that's what it is. And whereas for many other places, the courts get to filter according to the public interest in having it heard in the Privy Council. So ironically, I dare say the Court of Appeal has a greater capacity to filter out appeals to itself than onward appeals. The requirement to consider Guernsey law first is paramount.
What approach does Jersey take then if they don't follow the Morton and Paint?
Well, the approach which we'll get to in Guernsey is to say that there isn't binding precedent in the English model of binding precedent.
So Jersey.
Jersey.
Yeah. Oh.
Which we'll get to it.
Oh, okay, that's fine.
So, but restrictions on higher courts. Courts cannot overturn fundamental principles of Guernsey customary law. See Singleton. I don't know why I'm copying it here. So that case was about servitudes and the rule that you couldn't gain a servitude by prescription. Higher courts recognise that the royal court will often have the greater expertise in Guernsey customary law and resist innovation. So you wouldn't, the Guernsey Court of Appeals, particularly the Privy Council, wouldn't want to innovate about customary law if it's not been heard at the royal court level first. Maybe it might be different if the royal court judge themselves wasn't a customary lawyer, but the Guernsey Court of Appeal could potentially have the two bailiffs sitting in it, and therefore have greater expertise on customary law matters. But the general rule is that the British judges, whether sitting in the Privy Council or in the Court of Appeal, are sensitive to the fact that the first instance judges will often have the greater relevant expertise. It doesn't mean that they just simply defer. It does mean they're sensitive. There's a Jersey Court of Appeal case called Reed Barker that's quite useful there. If you ever cite Jersey cases, it's important to say it's a Jersey case and then say why Jersey cases are relevant. And Morton and Paint particularly brought in Lord Lowry's rules in C and the DPP. So it's good to memorise those as far as you can. You might say that these rules are not necessarily followed by the House of Lords or the Supreme Court in every case. You say, as I say in the study guide, that I think it's wait a couple of years and the House of Lords is making the enormous leap in Claremont, Benson and Lincoln City Council. But essentially, the idea is that big changes are things best left to the legislature. Certainly, if something requires a detailed code to be operated, then you can't, but that's possibly best left to legislators who can enact a code. Don't impose things if the legislature has rejected opportunities for reform. Don't try and resolve matters of complicated social policy. Fundamental doctrines, and this links with Singleton and Lenore, fundamental doctrines should not be set aside. And finally, and it comes to the question about doubtful solutions, well, don't make a change unless you can achieve finality and certainty, because it's a system of law. Law aspires to certainty. It's an aspiration, it's not something that's always achievable in all cases. But you don't want to make a change from a certain rule to a vague discretion, although heaven knows the courts do that often enough in England, particularly in the law of negligence. But these things are very much, because of Morton and Paint, this is how customary law can be developed, the limits of how it should be developed. So Morton and Paint, lots of things you need to know about. And this is why I describe it as a Lambeth and Cave cropping. And it caused significant discussion between myself and the Wilderness when we were preparing the study guide. Now, Lambeth and Kay is a decision to do with the European Convention on Human Rights, and in particular, whether or not you can rely on the European Convention on Human Rights in a landlord and tenant case so you can say, I have Article 8 rights with respect to my family life, therefore the council cannot or should not be allowed to evict me from my house, even though under landlord and tenant law I have forfeited my tenancy. To which the response in the English courts was, that can't be right, because you cannot have a greater right to live in a place than your contractual right with the owner. So in other words, if the owner is entitled to his house back, then you can't say that your right to have a roof over your head takes priority to that. That's a matter of property law. And it's the European Court of Human Rights said, no, we disagree. You do have an Article 8 right. It might not be one that's often sufficiently strong to win, but you have a right. And then it comes back in the case of Lambeth and Kay to the English system. Now, you don't need to know didn't really know the ins and outs just for illustrative purposes. But what was said when it got up to the House of Lords is, well, firstly they said, no, we still disagree with the European Court. We think you haven't properly understood the problem. In the end, actually, the European Court dug its heels in and the English judges backed down. But the important thing here is that what the House of Lords said is only the House of Lords could overturn its old case. The fact that the case is contrary to the European Convention on Human Rights, the fact that the European Court of Human Rights has made a directly contradictory decision, doesn't change the English rules of precedent. The English rules of precedent, the binding line, House of Lords can overrule itself, no one else can, has to remain in place. So it's for the House of Lords to decide what to do with the contradiction of the European Convention and nobody else. So, why did I think give this sort of name to this problem? Is, well, we've been told that the Privy Council from Guernsey binds the Guernsey courts, and the Guernsey Court of Appeal binds the Royal Court. But does that really make sense as a rule if you have subsequent decisions which demonstrate that the Privy Council wouldn't uphold its own decision? So if you have the position I used the Attorney General for Hong Kong and Reed as an example, if you have a position where a Privy Council decision has directly repudiated the binding precedent in Guernsey, and that Privy Council decision will almost certainly be applied by the higher courts in Guernsey, why should the Royal Court, just on the coincidence that there's on these rare binding Guernsey cases, insist that it's right? If, let's talk about the Cambridge gas case, let's suppose you have a Privy Council case from Bermuda, and then you have a Guernsey Court of Appeal case following it, and then that Privy Council case from Bermuda is overturned. Why should that case from the Guernsey Court of Appeal stay as strictly binding when it only ever purported to be following what somebody else was doing and somebody else has changed? Now, it's probably a niche problem. I quite like it because people interested in academic side of law tend to like niche problems. It's a niche problem because actually it's not going to arise very often simply because of the comparative lack of binding Guernsey precedent. It would be a big coincidence if a Guernsey Privy Council case happened to be overruled in this particular way. But if you have a situation like that, and I was talking earlier about Holly and the Attorney General from Jersey, if you have a situation where the Privy Council on appeal from another jurisdiction is explicitly stating that it's making a rule for the whole Privy Council family in an area of law where Guernsey follows that particular line of jurisprudence, or has always followed that particular line of jurisprudence, then it's rather unrealistic for lower courts to dig their heels in and insist on strict rules of precedent in the English sense. But
is that so? Who comes out where?
Well,
as between you and Gordon.
Sorry.
Gordon says that.
Well, Gordon says, and Gordon's ultimately right because it's what it says in Morton and Paint.
Right.
Gordon says, well, the rules of precedent are as found in Morton and Paint until the Guernsey Court of Appeal says otherwise. And so it's perhaps useful to understand the problems and the reasons why that's a potentially inconvenient rule for Guernsey, but it is the current rule. You also have the issue of customary law. Development is natural in the customary law. So, if you're trying to have a Privy Council decision, let's say of last year, and you want to rock up in the Royal Court and say, no, the Privy Council misunderstood Thomas Le Marchant. It got it wrong. That's one sort of attack. You're trying to attack the legal reasoning of the highest court, which even if their legal reasoning is open to attack, and I mean, often it is. Sometimes you'll read dissents where, you know, if you ever read, there's a case, the Attorney, Evans and the Attorney General, which is the one about Prince Charles's letters. The dissent from Lord Wilson really is, you're just totally barking mad, is his dissent. But it ultimately, you know, it's very difficult to try and re-argue a point that has just been decided the year before. But customary law, what if a Privy Council decision is hundreds of years old? Well, it can't be hundreds, it can only be 180 something years old anyway. But what if it's a Victorian decision and you're trying to say, well, customary law has altered because times have changed? That is the nature of customary law. Are you really trying to correct a legal error? Are you really trying to overturn a decision, or is it more, as for example, they might say in the English law of negligence, when they talk about what is fair, just and reasonable, that what is fair, just and reasonable has changed. Rondon and Worsley and barristers' immunity was right in the 1960s and wrong in the 1990s because times have changed. And that's a far easier argument in a customary law jurisdiction. So why shouldn't you be able to bring your customary law sources to bear? If usage, for example, like in the Buggins' turn case in Jersey had changed, why should that not be recognised at the Royal Court level just because the earlier case had somehow gone up to a higher level? But that isn't necessarily about departing from precedent, that's more about arguing the case afresh in a new era. So this is the view from Jersey. This is Sir Philip Ballash at his best. Jersey is not and has never been a colony to which the corpus of English law has been exported, and this is absolutely 100% correct. It has never been, the writ of the common law has never run to the Channel Islands. There's been trite law even in the English courts since the 13th century. the deep magic of the whole system, what the courts are there to do, is different. And your royal court still had legislative functions until 1948. So in other words, if you were faced with an inconvenient piece of law, and it was local law, then until 1948 the royal court could have dealt with it in a legislative capacity. Jersey caused trouble and had that changed in the 18th century. And here, the massive case law issue. So, and I think what Sir Philip Bailish is getting at here is that it becomes rather capricious when you have binding in the strict sense precedent and when you have persuasive precedent. If you've only got a few cases that have actually been come before the court. So if you've got something like Guernsey company law, you'll probably have comparatively few cases at all, and even fewer which would have gone up to the Court of Appeal level, let alone the Privy Council level, and achieved some sort of binding status. So to have these random points which are immovable doesn't necessarily make too much sense, although Gordon pointed out that this actually creates a very minor problem whilst avoiding the inherent difficulty of a lower court treating an upper court's decisions as if they don't matter. But of course it's not treating them as if they don't matter, because it's just recognising wriggle room, recognising the possibility of unusual circumstances. What the Royal Court wouldn't be able to do is to simply ignore last year's clear Court of Appeal decision. So should Guernsey follow Jersey's approach to binding precedent, although it will very, very rarely make any difference to the outcome of cases? Do we need to discuss it? Any thoughts? I mean, if you're answering this sort of question, you define your terms. Jersey's approach to binding precedent, Guernsey's approach to binding precedent. So, it's good to know the critique of binding precedent in the Channel Islands as set out in Qatar and Alfani, I think. And Jersey's approach is set out in Morton and Paint. And then you can add, sorry.
That's on.
And then you can add, you have the difficulty of that sometimes the strictly binding precedent will be contrary to later decisions of courts which quite plainly will be followed, whether that might be the European Court of Human Rights. And there's the Thomas and the Minister case, which I didn't mention, so I passed it, but it's over in the slides, and the study guide, which has been cited as precedent that the European Court of Human Rights should be followed rather than the rules of precedent, although when I read the decision I couldn't find where it said it.
What case was that?
It's called Thomas and the Minister for Housing. I read it because in the notes that I was given to help with preparing this, it was cited in that capacity, meaning that somebody knows something about it, and it might be that the report just doesn't do justice to the actual case. I'm not sure. But again, it's dealing with that problem of, well, why would you follow the Guernsey Court of Appeal decision on a particular point of customary law if there's a clear decision of the European Court of Human Rights that that's a violation of the Convention? Why would you do that? What advantage is there to doing it? The English common law has decided that, yes, it will go down that particular route, however. but it has a different level of cases. And has the expectation that everything is going to be escalated up quickly in areas of human rights. And it'll very rarely make any difference because there's such a low body of case law, but then this is the point made in our Qatar Al-Thani, that makes it terribly capricious as to when things are binding and when things are not. Green? Green well for time. Always remember your answer on what is always has to ultimately come back to Morton and Paint. Although you can say that there might be reasons why a court, why that might not ultimately be followed, the current rule is. Okay. Okay, let's just stop this and